So I'll just introduce myself briefly. My name is Broude. I'm a professor at the Hebrew University of Jerusalem and the academic director of the Minerva Center for Human Rights here at the Hebrew University of Jerusalem. And like most academic institutions, then we had a full slate of conferences lined up for the spring and the summer. But we've adapted with its pluses and minuses. And in that sense, it's great. The topic perhaps is not so great, but it's great to have this kind of international convention. Indeed, with the first webinar and the second one that we'll be holding next week on extraterritorial, the social minimum in the extraterritorial sense, people from, or speakers from 4 continents, again, taking into, I'm sure we could have had 5 continents, but the time zones, again, are somewhat of a limit. And here I'd especially like to thank Elena Pribytkova, who is the initiator of these couple of events. Elena is currently a postdoctoral fellow at the Minerva Center for Human Rights at the Hebrew University of Jerusalem, but as part of a program that is a joint postdoctoral program with Freie Universität Berlin. So I hope Elena's next year in Berlin will be less disrupted than the current year in Jerusalem, which of course was disrupted because of COVID, like a lot of academic activity. She's also a habilitation candidate at the University of Basel and has a JSD degree from Columbia Law School with a main expertise and focus on human rights law, international law, sustainable development, and certainly this interdisciplinary project of hers on extraterritorial obligations and socio-economic rights from philosophical, legal, and practical perspectives. So Elena, again, thank you for all the hard work and for gathering this excellent group of people and experts on the topic. Otherwise, I'd also like to thank people who are behind the scenes, literally. So Dani Evron, who is the executive director of the center, Liana Bernstein, who is literally behind the scenes. You might see a logo of the Minerva Center. She's co-hosting at the moment. She'll be making sure that everything runs properly. Anat Mishali and the rest of the staff. So Elena will give, I think, a few words of substantive introduction. We'll be introducing the speakers one by one before they speak. Generally, the format is about 10 to 15 minutes of each for people in the audience. The Q&A function is open and will be compiling. I'm getting a comment about the volume, then I will raise my voice because unfortunately those are the limitations of my technology. I hope that won't be a problem for others. So the social minimum issue has always raised thorny questions in human rights law, both in international law and domestic, so the territorial and extraterritorial dimensions. What minimum, whose minimum, what to provide, how to provide, who has to provide, what is its relation to equality. So the general questions are unsolved perhaps, but they're not new. But the COVID-19 crisis, not the disease itself, but I think its incredibly multidimensional impact has brought many of these questions to the fore in lots of policy areas. So health, of course, education, labor, social security, development, public and private finance, infrastructure, and of course, with special impacts on vulnerable and marginalized groups. But beyond the crisis, this also might be an opportunity that I hope we'll be able to develop in this discussion, and also beyond. What should be structurally improved? A lot of the problems that we're facing now were either well, they're issues of a lack of preparedness or a lack of awareness or a lack of willingness to take on the possibility that these problems would arise in a crisis situation. I'll stop there. This is really just for framing. Elena has a lot more to say, I'm sure, about these issues. But really, the goal of this webinar is to bring together a diverse set of experts from around the world to discuss these issues. Again, with a follow-up next week on today. The focus is on territorial issues. Next week on the extraterritorial or transnational issues that are, of course, also crucial when in a pandemic. So, Elena, take it from there.
Thank you very much, Tomer. Can everybody hear me? Yes? Yeah, great. Our two-part online symposium will discuss, as Tomer already announced, territorial and extraterritorial guarantees of a social minimum, which have been rigorously tested in the time of pandemic. The global crisis has revealed numerous imperfections and weaknesses of national, regional, and international mechanisms of basic human rights protection that are indispensable for protecting individuals from poverty and extreme inequality and enabling them to lead a decent life. Our symposium has three fundamental objectives. First, to discuss the most burning problems concerning the implementation of basic socioeconomic rights which humanity is facing today. Secondly, to explore what lessons should be learned from this global emergency situation. And thirdly, to discuss some directions for reforming local and global human rights guarantees and institutional design, which is necessary for ensuring a decent social minimum. The first today's webinar focus on territorial guarantees of a social minimum. According to the International Covenant on Economic, Social, and Cultural Rights, states have an obligation to spend the maximum of available resources to the full realization of socioeconomic rights, while immediately implementing their minimum co-obligations, such as securing access to primary health care, basic sanitation, basic shelter, drinking water, and essential foodstuffs. As the United Nations Committee on Economic, Social, and Cultural Rights has recently emphasized, states must take every effort to mobilize the necessary resources to combat COVID-19 in the most equitable manner, while prioritizing the special needs of the most vulnerable individuals and social groups, which are disproportionately affected by the pandemic. However, as we know, many states, along with non-state actors, appeared unable or even unwilling to provide adequate social support to their people. We are witnessing an unexpected paradox. Many states, which usually proclaim that they are welfare states, have not demonstrated this during the crisis, while a number of states which are traditionally skeptical of a social minimum have taken important measures for social support of their population. The pandemic has stressed an important interrelation between the democratic control over the distribution of budget funds and the realization of socioeconomic rights. From theoretical and practical perspectives, our speakers, leading human rights lawyers, Yuval Shany, Mikhail Windfuhr, David Bilchitz, Mary Belov, and Ignacio Saiz, will address, in this particular order, various problems surrounding a decent social minimum guarantees during the pandemic. I thank you very much, our great speakers, for joining us today. It's indeed an honor and a pleasure to have you here. We agreed that each of you will have 15 minutes for a presentation. After all the presentation, we will have about 40 minutes for questions and answers. And again, I would like to encourage our participants who joined the webinar to write their questions in Q&A box. Tomer, I give you the floor for introducing our first speaker, Yuval Shany. And
thank you. Thank you, Elena. Professor Yuval Shany is the Herr Schlauterbach Chair in Public International Law at the Faculty of Law at the Hebrew University of Jerusalem, formerly a dean of the law faculty, and he has been a member of the United Nations Human Rights Committee since 2013 and currently the vice chair of the committee, formerly also chair of the committee, and since 2018 he is vice president of research at the Israel Democracy Institute, with many other activities, including the chair of the academic committee of the Minerva Center, so he has the supervisory powers over this activity as well. I think I'll stop there because Yuval is, like many of you, is also quite well known enough. So Yuval, go ahead.
Okay, the most important affiliation is that I'm Tomer's neighbor, so we are living 200 meters from one another. So if I speak really loud, you may hear me without the computer. Okay, so thank you, Elena, for organizing this, and thank you, Minerva, for inviting me. It is a very topical issue, and this is I think it's a great format. So we are thinking about the substance today, and next week there's going to be the extraterritorial switch, which of course is very difficult, and I look forward to hearing about it more as well. I want to cover in my 10 to 15 minutes, I want to cover basically the approach which I want to raise, the topic which I want to raise has to do with the issue of life with dignity, which for those of you who are well-versed with the inter-American system is not a new concept, or not a very new concept. But for mainstream UN human rights law, this is still a rather unknown concept, or a relatively unknown concept. And the reason why I'm invoking it, which I, as you will see momentarily, I think it's immediately relevant to our topic of discussion about the social minimum. And I will also say a few words about its relevant to times of crisis and pandemic. It is because the reason I'm very interested in this particularly is because General Comment 36 of the Human Rights Committee, which was adopted in 2018, a year and a half ago, and for which I was the committee's rapporteur, this general comment on the right to life did introduce, as in a very prominent place within the general comment, the notion that the right to life also includes a life with dignity component, which was something that for the Human Rights Committee, that was an important step in introducing the concept into its work, and maybe also, as we will see, towards building a broader and maybe more sustainable bridge between our work and the work of the Committee on Economic, Social, and Cultural Rights that I'm delighted to see my friend Michaeli here. Representing it, but of course it's relevant for many other human rights activists, academic courts, etc. So what is this right to life with dignity? I mean, the general comment, I should say, does not define the right to life with dignity. It merely says in paragraph 3 that the right to life should not be interpreted narrowly, and that it concerns the entitlement of individuals to be free from acts and omissions that are intended or may be expected to cause their unnatural or premature death. So this is the traditional understanding of the right to life as the negation of death. And here comes the addition, as well as to enjoy a life with dignity. So this is so the right to life, according to this understanding, has two prongs. It has the protection of physical existence, and then it has this additional prong, which is an entitlement to a life with dignity. Now, as I said, the general comment does not define the notion of a right to life with dignity, but it does give you some ideas, because it already implements in certain specific contexts this notion within the general comment itself. And as you will see in the case law of the committee, in the post-2018 case law of the Human Rights Committee, which takes this notion of life with dignity and actually implements it in specific cases. So in the general comment, the notion of life with dignity is mentioned in connection, for instance, with the very thorny issue of euthanasia, whether under certain circumstances persons may ask to die with dignity, which is of course an odd idea to, I mean, this is an uneasy topic to raise within the context of a right to life, the notion of the right to die with dignity. But the right dignity is mentioned in this context. But perhaps the more interesting for our purpose is paragraph 26 of the general comment, which is the paragraph that deals, it's a very important paragraph of the general comment, which deals with, so to speak, background conditions, namely general conditions in society that may give rise to direct threats to life or prevent individuals from enjoying their right to life with dignity. So this spells out the long-term or more infrastructural obligations of states that derive from the right to life, including the right to life with dignity. For instance, environmental degradation. Fighting environmental degradation falls within these, the need to take appropriate measures to address the general background conditions. The issue of deprivation of indigenous peoples, lands, territories, and resources comes within this context. Of course, safety issues such as gun control, traffic accidents, the prevalence of life-threatening diseases, widespread hunger, malnutrition, extreme poverty, homelessness. So you see, we already have a notion that is quite flexible and does allow the committee to look at background economic and social conditions whose absence would have a detrimental effect on the ability to enjoy the right to life with dignity. Now, I will try to provide a couple of words of how I see this, where I see the center of gravity of this concept, and then I'm going to run very quickly over a few examples of actual cases that the committee has held, and then say something about the relevance to times of pandemic. So for me, why did we introduce this notion? We introduced this notion of life with dignity because dignity is already mentioned in the ICPR, in the preamble. And of course, dignity is also a notion that one finds as a very central notion in the UDHR, in the Universal Declaration. And I think for us, the notion of a life with dignity, which I would argue that the notion of dignity infuses all other rights. So it's not only the life with dignity. You can think of other rights that have a dignity component. But for the right to life, the idea of life with dignity is that persons are entitled to be treated or to live in conditions which are reflective of the value which is attached to human life. So so the critical issue is the acknowledgement of the worth and value attached to human life, and this is the flip side of life with dignity. And I think it does sit quite well with some of the inter-American understanding of vida digna, as conveying the idea of, for instance, the Inter-American Court already in the late 1990s talked about in the Morales case about the allowing people to harbor a project of life as part of this life with dignity notion. We see later the court dealing with extremely precarious conditions of existence as falling under, as potentially incompatible with life with dignity, basic necessities. And I would argue that you can think of other situations of humiliating conditions of existence, or conditions of existence of treating people as humans as subhumans, where you could employ this idea. Now, in actual practice, since 2018, the committee hasn't had a lot of chances, because this is a very recent general comment. But I would argue that we already had. There have been already 3 major cases that the committee, Human Rights Committee, had issued using the notion of life with dignity, where I would argue that this has already made a difference in the outcome of these decisions and in the framing of these decisions. So how am I doing on time, Elena? How much time do I have? 5? Okay, so one case is this Toussaint case, Toussaint versus Canada. This is a 2018 case. This is a case about access to health services. It's a case involving a migrant who had an irregular status in Canada. She was in the process of regularizing her situation in Canada. Eventually, she did get residency, but in the interim, she was excluded from entitlement to a certain temporary healthcare program. She had background health conditions, and her exclusion from the program did put her did risk her life. I mean, this is actually the Canadian courts themselves acknowledge that excluding her from the healthcare program did put her life at risk. So for the committee, this was not only about putting her life at risk, which is in itself maybe a potential violation of the right to life. I mean, the right to life could be violated by a mere risk to the right to life. The risk doesn't have to be realized in order for the violation to occur. But it stands to reason that the committee was also concerned about excluding a person in a situation of vulnerability from healthcare coverage on the basis of an immigration status as a form of treatment which is incompatible with recognizing the value attached to her life. So I would argue that this is also, and the committee actually mentions life with dignity in this specific case. So I would argue that this is why we mentioned life with dignity, because the treatment was incompatible with full recognition of her worth, full worth as a person. A 2019 case involving Paraguay, Caceres, a case about an environmental pollution, a case involving farmers who were adversely affected by the use of chemical industrial pollutants. In that case, it was chemical pesticides that were used by industrial farming. And this caused them significant health problems. I mean, the spraying of the farms, and one of them actually died. One of the farmers actually died. And again, Paraguayan court did establish a connection. So it was clear there was no question that the use of pesticides risked life and also caused a deprivation of life. But again, for the committee, the committee framed this issue also as a life with dignity issue. And I would argue that the placing of individuals under conditions in which they are exposed to life-threatening chemical pollution is incompatible with the value that should be attached to their lives. And the third and final case, which I have in this series, is the recent Territorial case. It's the 2020 case involving New Zealand. And this is a case about a so-called climate change refugee from Kiribati, who argued that sending him back to Kiribati, an island that is facing eventually the threat of being submerged underwater because of rising ocean levels, this is an issue which could potentially raise life with dignity issues. The committee in this case found that there was no violation at the time that he was sent back, because the conditions on the island were harsh, but still didn't fall below the minimum. But it did explicitly state that it can envision in the very near future a situation where it would decide differently on such a case. I see that my time is very rapidly disappearing. So let me say perhaps three things, and I will conclude. First, I would argue that life with dignity, the committee has relatively few cases on life with dignity, but I can see a very strong connection between this case law and the case law that the committee has developed on Article 7, on the freedom from being tortured or subject to cruel, inhuman, and degrading treatment and punishment. And the committee has case law, especially in deportation cases, where sending someone to, especially in the Dublin context, and sending within Europe people back to countries like Greece or Italy or Bulgaria, where they would be living on the streets under situations of vulnerability. The committee has found in the past that this could raise Article 7 issues. I think that the analysis here is quite similar to the analysis that is done in Article 6, right, to life with dignity cases. So there's another interesting bridge, this Article 6, Article 7, and economic, social, and cultural rights. Secondly, I should say that the issue of this whole approach has been subject to certain criticism. It's not something that everyone is happy about. Maybe we can develop this further in the Q&A. I will just note for the time being that there is a general concern about overburdening rights and about cramming too many all human rights within Article 6 is not something that is being viewed as a very positive development. Of course, I think that this is not what we are doing. We are talking about the bare necessities, the social minimum here. But this is something we can develop going forward. I do want to use, I'll steal 1 minute just to say on the pandemic, because this has been my title and I feel that I didn't give the audience its money's worth on this. And this is, look, how is this life with dignity relevant to the pandemic? Of course, the very pandemic is a serious threat to life itself. I think there are some elements that we should be looking at the response of states and analyzing it not only through the issue of physical existence, but also through the question of value attached to human life and life with dignity in particular. So for instance, discourse about herd immunity that suggests that we can allow a few thousand people to die in order to obtain on the more general societal level immunity. This is not necessarily commensurate with the idea of treating individuals as ends and not as means. That is recognizing their values as human life. Also statements of presidents in Latin America saying that's life, we will all die one day, may also reflect this indifferent approach to human life. So it's a question of, are your actions compatible with recognizing the value of human life? The balancing between opening the economy and closing the economy is also relevant, although I should say that extended lockdowns may also raise questions of life with dignity on the other side of the spectrum. So this is, of course, important. Excluding people from healthcare, access to healthcare or from testing. It's a discrimination issue, but potentially also a life with dignity issue. Falling below the bare minimum in places which are already hovering above the minimum, such as prisons. In times of pandemic, you should ask yourself whether the conditions have not fallen below the minimum for a life with dignity. And finally, in deportation cases, sending people back to countries in a state of pandemic could raise issues whether their life with dignity has been fully internalized. So I apologize for stealing 1 minute, and I look forward to hearing questions. Hopefully there will be some opportunity for me to further elaborate in the Q&A. Thank you very much, Elena, for your indulgence.
Thank you very much, Professor Yuval Shani. We will proceed with the presentation of Michael Windfuhr, who is a political scientist educated at the University of Heidelberg. Since 2011, he is the deputy director of the German Institute for Human Rights, the national institution for human rights in Germany. Since autumn 2014, he is a member of the independent complaint mechanisms of the European Development Finance Institution, DAG, FMO, and Proparco from Germany, the Netherlands, and France. Beginning of 2017, he started to be a member of the UN Committee on Economic, Social, and Cultural Rights. Prior to this, he served as Human Rights Director of the Broude for the World, the development organization of the Protestant Church in Germany. Between 1988 and 2006, he worked with FIAN International, an international human rights organization that focuses on the realization of the right to adequate food. He publishes extensively, particularly on socio-economic rights, trade, and agricultural policies. And the topic of Michael Windfuhr today will be the right to social security, state obligations, and responsibilities of other actors. Does it cover guarantee of a social minimum support? Thank you very much for joining us today, Michael. I give floor to you.
Yeah, Elena, thanks a lot for inviting me and giving me the chance in this very condensed format of 15 minutes to explain also how the Committee on Economic, Social, Cultural Rights thinks about this right to social security. And I have a short PowerPoint presentation, and I hope it will work. So let me see how I can start, or maybe you can start it from your angle. Yeah, that would be helpful for me. I think I send it to you in advance. It would be nice because I don't see it at the moment. So let me start by saying the Committee on Economic, Social, Cultural, Human Rights made a statement on the coronavirus pandemic and economic, social, cultural rights, which Elena has already mentioned. We published this on the 6th of April, and we were saying that the pandemic shows the indivisibility of all human rights. One further, yeah. It stresses also that rights of most marginalized individuals and groups are often disproportionately affected by the measures taken to combat the pandemic. We were highlighting that there's a critical issue that you can see if you haven't had adequate investments in the years before to the public health system, to decent work, to food, housing, and the sanitation service. In order to respond to the health crisis, the impact is even larger. And it emphasized that some decades of austerity measures in many countries has led to a lot of cuts in public support to the health sector, but also to other relevant programs and policies. And and also to the maybe privatization of certain services. And we mentioned that at the end, very important for states is to use really the maximum of available resources, which combines at the national level using discussing the income side you might have on taxes, but also the expenditure side for what type of things you spend your money. And there's a lot of more potential in all countries worldwide. It also mentions, and that is maybe going to the Monday agenda then, that there is an international cooperation obligation, assistance obligation, which might also talk about sharing resources, sharing research results, and an extraterritorial dimension, which talks about issues like access to essential medicines, intellectual property rights, and vaccines, and so forth. Let's go to the next slide. And I will now have 7 observations just to cope with the 15 minutes to share with you, and I might answer them many more things later. Just if you look to the, let's say, where the right to social security comes from, you see the Universal Declaration of Human Rights, Article 22 and Article 25, and it talks about national efforts and international cooperations, both sides already. And it talks, the objective of this right is to have free development of his personality. I added here her just to the text. And then if you go to the Committee on Economic, Social, Cultural Rights, is our Article 9 on the right to social security, which is very short. And we also made a general comment in number 19 in 2007. And it might be already in the need for a review. We are discussing it because times is going further, but in 2007, we have already mentioned, and this links to the Committee on the Human Rights Committee, that this is essential for guaranteeing human dignity for all persons. And it's basically about the right to access and maintain benefits. And you can see how it is described. It says related to work, to lack of work-related income, out of different reasons, unaffordable access to healthcare, and insufficient family support. So if one of the 3 things happen, you need to have access to and maintain benefits. That is important. And it's also mentioning the redistributive character it might have to overcome exclusion in societies and for poverty reduction. If you also take on board what the ILO, the UN specialized agencies, which is very relevant for this sector, has developed, you can see that in the Philadelphia Declaration founding the ILO after the Second World War, it's saying the extension of social security measures to provide a basic income to all in need of such protection and comprehensive medical care. And you can even see that the ILO has this further developed by the concept of decent work, which is more than 10 years old. And one of the 4 pillars of decent work is social security. Without that, you have no decent work. And they have also developed, the ILO in the last years, this idea of a social protection floor, which would then cover just more than those social protections guaranteed or linked to formal work. If we go to the next, you see, my first argument was the right to social security is a mix of components. I think that is made very clear. And the second, I would like to say, my second argument is it's really core for human dignity, and we can't underestimate the core right of the social security for the guarantee of human dignity. Just to give you a few examples, in the Brazilian context, the Bolsa Familiar, which was given some years ago, this basic income grant, which was handed over to 50 million families in a short period of time, was the sharpest instrument ever used by states to reduce poverty. It has the sharpest poverty decrease in that period in Brazil, which you can find worldwide. And it was just giving a certain amount of money to families. And it was often said it's giving the money to the lazy ones. But what was important, and there's a lot of studies which really shows it was deliberating those who are receiving the money, not to look always for the money for the food for the next morning or evening. It was delivering families in order to seek more for, let's say, education or other forms of dignified life. The right to adequate standard of living contains food. If you don't have enough food or nutritious food for your baby in the first 1,000 days, that's what the World Health Organization is saying, you have deficits you will never overcome. Again, in your whole life, you will suffer your whole life from some problems. Yeah? And even in richer societies, we just had a statistic in Germany that those who live maybe with inclusion problems, also due to income, have a hard difference in life expectancy is more than 10 years between the upper decile and the lower decile in our country. 10 to 12 years of life expectancies differences has a lot to do with the, let's say, guarantee of a human dignity, as Yuval has also introduced this. If you go back to Amartya Sen, we know that you have 4 forms of incomes. You can either produce as a peasant, you can have a labor income, a trade income, or a transfer income. It shows already how important this transfer income is if the others don't function. And that's where the history for Social Security came from. It was first replacing those risks linked to labor, to wage labor, like in accidents and so forth. But we have to think further. It's not only the wage labor which needs to be replaced, but also all other forms of income, particularly in the informal sector. And if you see to the Corona response in countries where 70–80% of the society is in the informal sector, you can see that it's not only the replacement of formal job incomes which is needed, but it has to be brought further. My lesson here at this level is we need a change of a mindset. The right doesn't make somebody dependent, but it liberates people. It offers chances. It gives people a self-determination on their own life decisions. Let's go to the next. Just briefly, it's important to differentiate that we have a broad mix of instruments. Yeah, we have contributory systems, insurance-based. We have non-contributory systems where people don't pay themselves to get something out. They can be universal, oriented towards all people, like the Bolsa Familiar in Brazil, or it can be targeted to social poor groups or social other groups who get a certain form of assistance. And it shows the more emergency situations we have, for example, or the more it comes to the minimum, the more it is important that the schemes are universal and not only linked to contributory systems. If you go to the next, and particularly for the informal sector, you need this broad-based, more universal systems. I have just made a short picture, which you might see what is a low protection level and a higher protection level for Social Security, and low income and high income at the 2 axes. And you can see how the different, let's say, instruments work together, and social protection floor would be a universal non-contributory system, would be basically the ground floor. But you can also see that some of the insurance-based systems, be it contributory or voluntary systems, even only contribute to a certain segment of the society. Let's go one step further. You can see the standard of interpretation. The committee has evolved in all the general comments. 19 is just cut, sorry. The 3 levels of obligation: respect the state itself, has not, shall not discriminate or hinder people to have access to Social Security measures because they belong maybe to a certain minorities. Protection means the state has to make sure that private partners pay their bill, for example, companies. And then the fulfillment obligation says the state has to enable people that they can really live in dignity in that sense. Facilitate is it shall help that people can have access, but it should also have in a certain moment to provide, particularly if people are not able to feed themselves or to deal for themselves because they might be too old or might be too young. So there are a lot of groups in the society where a provision is extremely important. If we go to the next. And the committee has interpreted the covenant in that way that you really have to take steps for each of the vulnerable groups. That is what the state has to prove. They have to start immediately and cannot say we will get some money in 10 years. That is not adequate. And they have to accept all the procedural rights, non-discrimination and transparency. And particularly to show that the maximum of available resources is there. And that relates, as I said already, the income base needs to be checked the tax system, tax evasion is the tax system progressively, and tax systems are in some countries extremely low. And you can also look at the expenditure base, how reasonable is the spending, how proportional is the spending, is there any discrimination form involved. That's how we check and monitor, let's say, the efforts of states to implement the right to social security. Let's go to the next. Yeah, what is important for the national implementation is really also the content. Services needs to be available. They need to cover all the risks which are important. They needs to be adequate. That's what you can find in General Comment number 19. And they need to be accessible. And then we come in a moment to the question, what is the minimum then of the right to social security? An issue Thomas was asking at the beginning already, which is always very debated. Important is at least each state shall have a national strategy based on the identification of the most vulnerable and particularly affected persons and groups, and they need to be covered by resources. And against this, you can check if the state is really doing the best. And very much depending on the, let's say, implementation of the right to social security is also the question, how responsible are the institutions how responsible is the governance, how much bad governance, corruption is there, the link between non-discrimination and social exclusion. Let's go to the next. In the response to the pandemic, now you can see that many of the, let's say, measures taken has not been based on any adequate analysis of the vulnerable groups, which should be affected either by the pandemic or by the measures taken to combat the pandemic. Human rights impact assessments are missing in most countries. And this leads to that particularly affected individuals and groups of the crisis itself, like health workers, are even maybe identified as those who need better support, but largely informal sector and other segments has been really overseen, also in their cost of the access to the health service, but also just getting an income to survive. And in many countries, the pandemic measures also don't work because people are too poor just to stay isolated at home. So what is important is you need the extreme sensitivity and identification of the people in need. And this has to be taken in each crisis again and again. And you need to have a proportionality test and a reasonable test of your measures taken. Maybe we go to the next. What does it mean now? And I have 3 minutes left. I've just seen. What does it mean if we go to the discussion? Maybe you can go one chart further. Let's say is there any type of a minimum core? And well, the general comment number 19 was saying it is to ensure the satisfaction of the very least minimum essential levels of each right. This is what is always used as a term. But first, for me, it's important to say maximum available resources doesn't mean only financial means. It might mean access to health services free, or maybe access to food or food producing resources, which would allow to feed yourself, or access to drinking water. These are elements which also needs to be checked as not only financial matters. Then states have an obligation to seek also international support when resources are missing. It's mentioned in General Comment 19 as well in others. And better is to have towards a universal coverage. Now you have often the argument this can't be covered by poorer states. But this is something interested in, if you talk about the reasonable spending of the availability of resources, because often basic social income grants at the universal level are not totally out of reach, even of poorer countries. We can go into this more into the discussion. So what is most important is often not the resources which you have, but it's the political will to use the resources which you have also for this minimum social income grants. And the international support should also consider supporting maybe these type of financing. So something like Bolsa Familia, and not only say we only support maybe proactive investments. This is an investment in persons, and that needs to be understood. Let's go to the next. I have one slide which talks about the relationship between business and other actors in social security, and the UN Guiding Principles are reminding us that you obviously have a responsibility to respect, do no harm, but also companies have a responsibility to make social security checks, social security due diligence tests. And we have a lot of cases they're obliged to have contractual obligations to pay insurances, for example. They have they should contribute in that sense also to the social security coverage of each state, and they can't say, no, it's an emergency, we can't pay anything, but we might still pay some stock exchange funds and things like that. So it's very important. The business actors should also not hinder the state to implement economic, social, cultural rights, maybe through lobby work or bribery or tax evasion, which would limit the availability of resources, or by making transfer prices, which helps that in poorer country nothing is left from the production, but everything is transferred maybe to states where there is a bigger tax haven. So there is a big responsibility, and I can go into more details in discussion. Let me conclude by summarizing what I have said, and you can see it on the next slide. Very briefly, the right to social security is therefore a backbone for the realization of economic, social, cultural rights, for human dignity. The policy response needs to be regularly reviewed in order to don't oversee a marginalized group. And it's very important that we change the perspective away from that social security is a payment to let's say, lazy people, but it's an activating role to self-empowerment. Other actors also have to understand that they have social security obligations, and they have to make their own human rights due diligence checks, particularly business. And yeah, the companies have to think about how they operate in these circumstances. They can't just cancel all the orders they made maybe in the textile industry of Bangladesh and say we have nothing to do with the payment of salaries or maybe social security minutes from one day to the other, as it happened in this crisis. They have to think about their own responsibilities in this context. So that is all what I wanted to say in 15 minutes, and it was now 16. Sorry for that.
Thank you very much, Michael Windfuhr. And we are now moving to our next speaker, David Bilchitz. And Tomer, floor is yours to introduce him. Thank you very much. Tomer? Let me...
No, I'll
okay.
I wasn't going to say much.
Okay.
We're moving from Berlin, not to Johannesburg, but to the UK, but very much also with, I hope, a South African and global perspective. Professor David Bilchitz is a professor of fundamental rights and constitutional law in the Faculty of Law at the University of Johannesburg, director of the South African Institute for Advanced Constitutional, Public, Human Rights, and International Law. Lots of other points, but perhaps the most important is his extensive writing on socio-economic rights, including his book on poverty and fundamental rights. And I am also more familiar with David's work on business and human rights, which very much ties in, I think, to Michael Windfuhr's last comments on the involvement of the private sector, which is something that we could perhaps also get back to in the Q&A. So David, please.
Thank you very much, Tomer, and many thanks to Elena and the Faculty of Law at the Hebrew University for the invitation to participate in this timely seminar. I'm just trying to share my screen. Let's see if that's going to work.
Yes, that's great.
Is the screen working?
Yes.
Working.
You can see it. Okay, very good. Is it a full screen, or is it?
It is now not a full screen.
Not full screen. Let's just try and get it full screen. Okay.
Yes. Yes.
There we go. Great. That's fine. Excellent. So COVID-19 has thrust socioeconomic guarantees into the limelight in a way that is rare. Right-wing governments traditionally committed to austerity are suddenly engaging in widespread social expenditure, and in some cases, extensive social protection programs. It is thus an opportune time to reflect on the notion of the social minimum and the extent that it can assist at this time. My focus in these short remarks will be on some complexities that arise in determining governmental positive obligations at a time of health crisis. What do our fundamental rights frameworks tell us about how governments should and must respond? This is a large enterprise, and given the topic of the seminar, the focus will be on socioeconomic responses. In the limited time available, I'm going to hope to accomplish the following things. First, to make a few remarks about the nature of a health crisis. Secondly, briefly to discuss an important contrast between a focus on socio-economic rights and the conceptual notion of the social minimum. Having done so, I will seek to outline and apply the minimum core approach to positive obligations underlying socioeconomic rights at this time. In doing so, I shall hope to show how the approach itself embodies a number of important questions governments have had to make, as well as demonstrating the irrationality of certain decisions. I end with a few remarks on the reasoning process for dealing with trade-offs between important key considerations that arise, particularly in light of a scarcity of resources and capacity. To add an African flavor to this event, as you said, Tomer, my examples will be drawn generally from South Africa, which to some extent I would suggest is emblematic of the specific problems faced in the global South, though some of these problems have been shared with other countries in the global North as well. So in order to conceptualize the obligations of government, and let me bracket here, I'm focusing on government and not the private sector because of time, and I appreciate Michael having discussed briefly the private sector, we need to start with understanding the phenomenon that we are dealing with. In a prior article, I have examined the notion of economic crisis and divided it into three components. For our purposes here, I would like to apply these thoughts to a health crisis such as that of COVID-19, which has its own particularities, and I'll only mention two of the notions. In relation to this kind of crisis, we have two sorts of threats that place individuals in a state of what I term personal crisis. That is a situation in which individuals are in desperate circumstances and lack the ability to meet the very general necessary conditions for being free from threats to their survival or basic well-being. The virus itself poses a severe threat to health, and thus can itself place many people in circumstances of personal crisis, though its effects are also not uniformly spread through the population. If people fall seriously ill, that illness itself can prevent individuals from being able to access livelihoods. A health crisis thus can turn into a wider personal crisis. But perhaps most importantly here is the fact that the very measures taken by many governments, or most, to respond to the virus and protect individuals pose a severe threat to the livelihood of individuals. Even if they are healthy, many people are unable to work, millions are losing their jobs, and they consequently lack income to meet their basic needs, such as acquiring food and paying rent. In addition, social distancing measures increase social isolation and can also bring on a mental health crisis. Given the large number of people affected in such a pandemic and the serious economic effects, the crisis is not only, I would suggest, a personal crisis, but what I term a structural crisis. Such a crisis is a circumstance in which many individuals are in circumstances of personal crisis. The situation is connected with imperiling a social or economic system or structure, and there is a scarcity of resources in being able to address it. COVID-19 would constitute, in my view, according to these criteria, such a structural crisis too. Now, both personal and structural crises require governmental intervention. But what is the legal analytical framework within which we must conceptualize its obligations? To begin with, the effects I have described of a health crisis clearly implicate socio-economic rights and the obligations of the state flowing from these rights. Those obligations are included in some constitutions and also, of course, flow from the International Covenant on Economic, Social, and Cultural Rights, which we've just heard about, and indeed in the wider approach of the International Covenant on Civil and Political Rights that Yuval discussed. I would suggest one of the key facets of a rights-based approach, importantly here, is disaggregation. That means that there is a separate focus on the right to housing, to healthcare, to food, to water, to education. And this, in my view, was of great importance. Instead of aggregating all individual interests together, we are forced by fundamental rights discourse to think through the separate effects on and obligations flowing from each of these different rights, which protect different individual interests of individuals. That allows us to recognize that there are a range of dimensions in which individual lives can be affected, and to understand where there are trade-offs and how to engage with them. Such clarity, as I will explain, is most important when considering governmental obligations in relation to a health crisis, where the need for an urgent response can undermine clear thinking. At the same time, there is a fundamental interconnection between the various rights and interests of individuals. This is something that is also strongly highlighted by the crisis, as I'll outline. It is also true that despite the fact that we have differing interests in housing and food, they all contribute towards the well-being of a single unified individual. It is thus necessary to consider how the interests interact and overall social policy in this regard. I would suggest that the usefulness of the concept of the social minimum, which is the basis of the seminar, lies in this process of aggregation and pointing us from the trees to the forest. And I'll be very interested in Elena's thoughts, who's done a lot of interesting work on this very notion of the social minimum. Having made this distinction, what then are the obligations of the government towards individuals in a time of health crisis? Well, clearly of great importance is ensuring that people are not harmed in their possession of what they already have, for instance, being evicted from their homes. South Africa and its regulations importantly prohibited eviction during the most intense time of the lockdown. This duty to respect rights also must be complemented by a duty to protect, to ensure non-state actors, for instance, do not harm individuals during this time. The engagement by the government of South Africa, for example, with the banks to ensure a mortgage payment postponement would constitute one such measure. My focus, however, will be on what must the government actually provide, the obligation to fulfill in times of crisis. The literature on socioeconomic rights has been engaged with a discussion between those who are proponents of a reasonableness approach and a minimum or core approach towards determining the obligations of government. Now, I won't rehash this debate here, but suggest that the minimum core approach is particularly well suited to situations of crisis. Not that it's not suited to other contexts, but it's particularly well suited here. I am interested, though, in exploring some complexities that arise with applying it given the particularities of a health crisis. So firstly, let me summarize three main components of the approach. The first involves the identification of at least two thresholds of provision, one of which has a particular urgency. And interestingly, this ties in very nicely with the Human Rights Committee's approach and also much of the work of the Committee on Social and Economic Rights. In my book, Poverty and Fundamental Rights, I argue that the minimum threshold can be formulated as guaranteeing individuals the general conditions necessary to be free from threats to survival. The second sufficiency threshold, or the perhaps life with dignity, as is suggested by Yuval, concerns the general necessary conditions to be in a position to realize one's purposes or to live a life of dignity. I have argued in prior work that some societies will find the universal minimum core specified, the survival threshold, too minimal, and rather seek to specify a minimum threshold their society regards as the standard below which individuals should not be allowed to fall, or what I term here a relative minimum threshold. The second component of the approach is a prioritization of the urgent dimension in cases where the higher threshold cannot be fully realized. Related to this is a strong burden upon the party who wishes to justify any failure to meet this minimum. And lastly, there is a duty to increase provision from the minimum to the sufficiency or dignity threshold, a process that employs the concept of progressive realization. This approach, I would suggest, is particularly well suited to a crisis. First, it requires the development of a threshold below which individuals cannot be allowed to fall without a very strong justification. Secondly, it focuses on the important notion of prioritization at a time where not all needs can be met. And finally, it is meant to apply to every individual and stand against any exclusions for anyone facing threats to their survival. So let's look at it in the context of COVID-19, which raises a number of interesting issues in the application of this approach. In relation to health, clearly COVID-19 poses a threat to survival in some instances. It still remains relatively unclear the percentage of people who die from it, nor why some people become much sicker than others. That lack of clarity creates a sense of fear and vulnerability that in all of us, that any one of us could potentially die as a result of the disease. This has led societies to focus large amounts of resources towards combating the disease and also to treating those who are severely affected by it. The notion that we all could potentially die gasping for breath where a technology exists to preserve our survival has led to a vast expenditure on expensive ventilators and new hospital facilities for those in these conditions. That expenditure has increased at the expense of expenditure on other conditions. The Economist reports that the battle against the novel coronavirus has led to a sharp drop in spending on other conditions, with non-urgent care cancelled and patients avoiding hospitals and clinics. Anecdotally, I've come across cases in South Africa, for instance, where appointments for the treatment of conditions such as cancer were stopped during the lockdown for coronavirus, something borne out by certain reports I've read in preparation for the seminar. These are not isolated cases, as also effective access to essential medicines has often been curtailed. During severe lockdown measures, people without transport has also been unable to access hospitals in order to acquire life-saving medication and treatments. What is clear is that the coronavirus is not the only threat to survival. Many other conditions create such threats too. The coronavirus may in fact have a lesser chance of harming someone who has some of these conditions. Yet government regulations and priorities have been focused on one particular threat over many others. The minimum core approach would require us to understand the range of serious threats that exist, rather than focus on only one particular threat to survival. The approach highlights the irrationality of many governmental responses that have focused solely or mostly on coronavirus and would require governments to craft a response that addresses this range. I don't say that government shouldn't address coronavirus, let me be clear, but it isn't the only aspect of health that it requires looking at. It also has, in a sense, highlighted the weakness of existing justifications for failing to provide other expensive life-saving treatment to individuals. Consider the vital drug called Herceptin, which is effective in certain treatments of breast cancer. It was unavailable for many years in the South African public sector because of the high cost, around $35,000 per year. Hopefully, the response to COVID-19 will highlight the fact that governments are able, with the necessary will, to respond to many healthcare conditions that threaten survival and challenge the justifications for failing to do so. There are thus interesting trade-offs with the right to health, but also importantly with other socioeconomic rights. The lockdown measures created for many a real threat to their livelihoods. Unable to leave home and go to work, many people could not earn an income. These include waiters, drivers, informal sellers on the side of streets, and many others. The lack of an income has in many cases imperiled the ability of individuals to access food. Malnutrition is once again rearing its head in South Africa. As such, the survival of individuals is being imperiled not only through the coronavirus, but through other causes. It makes no sense, as has happened in India, to create a crisis of hunger in order to avert a healthcare crisis. These effects place obligations upon the government to provide a guaranteed level of economic support to individuals to enable them to survive. The difficulty in global South societies is often the capacity to provide such assistance quickly. Lockdowns have also prevented soup kitchens and private charitable solutions from working in these situations. The universality of these guarantees is also particularly important. Inevitably, some have borne the brunt of the lack of livelihood worse than others. Furthermore, governmental programs have often by design or default landed up excluding highly vulnerable people. Foreigners in South Africa have been unable to claim the meager social assistance grants provided by the government, which were earmarked only for South Africans and some other categories, permanent residents and refugees. And this is very low, about $25 per person. Many of these foreigners were informal workers who lost their income completely during the lockdown and landed up in a state of utter desperation. Once again, it is irrational to try to save lives from a virus through measures that create threats to the survival of other people. Reasoning around socioeconomic rights thus requires governments to track the effects of survival in relation to every right. The minimum of core approach would require a prioritization of governmental obligations in relation to any threat to survival flowing from any particular right. The problem that coronavirus creates is that some threats to survival may in fact be created by attempts to avert other threats to survival. Lockdown measures, as we saw, can hamper access to food in aiming to stop the acquisition of a disease. I would suggest this is a classic case of conflict of rights, and we need to utilize the reasoning structures developed in constitutional law to address this, as has already been mentioned, the process of thinking proportionally. If we are going to create a threat to survival through a particular measure, we need to have a clear idea of the purpose of the measure and whether it is rationally connected to achieving the purpose. A crucially important step is necessity, whether there is an alternative that can still sufficiently achieve the purpose but have a lesser impact on the right in question. Some measures have unnecessarily created threats to survival. And finally, ultimately, there will still be a need to balance the costs of one measure in one dimension against the benefits in another dimension. The outcome of these processes of reasoning, when aggregated, will allow us to understand, I suggest, what social minimum should be guaranteed in times of health crisis. It is sad that reasoning around fundamental rights often is not the basis on which governments decide. This is part of what I'm trying to put on the table. That is what needs to be at the center. It is necessary to change that and for governments to be required to justify their responses in light of the principles I have articulated. We initially must begin by disaggregating these effects, but in arriving at a final decision, consider them against each other to arrive at an aggregating measure, namely what we will arrive at will be the decent social minimum. Thank you very much.
Thank you very much, David, for a very interesting presentation, as all our presentations, and bringing us to another aspect of the problem while developing the previous presentations. Now I will move to the next speaker, which is Mary Belov. She is a professor at the University of Buenos Aires, where she became the first woman to hold a chair in criminal law and criminal procedure in 2013. She regularly teaches courses on theory of punishment and human rights, criminology, gender and criminal justice, child's rights, and juvenile justice. As a visiting professor in different Latin American universities, Professor Belov was delegated with the responsibilities of providing continuing education to judges, prosecutors, public defenders, and NGOs members. As a legal advisor on criminal justice and human rights matters to various Latin American governments and international organizations, UNICEF, IDB, UNOPS, OAS, UNDP. She has been involved in adopting international human rights law at the domestic level through legal and institutional reforms all over the region. Professor Belov also drafted some modern Latin American legislations on child protection and juvenile justice, as well as adversarial criminal procedure codes in several countries. In 2007, she was appointed Attorney General on Criminal Policy, Human Rights, and Community Services at the Attorney General's office in Argentina. Mary, thank you very much for joining us. You are going to present on the Inter-American Court of Human Rights decisions on dignified living conditions under the COVID-19. Are you going to share the presentation, or you will just discuss, just speak? Hi, Mary? Yes, hi.
Thank you, hi. Elena, Toma, colleagues, I'm glad to be here. Thank you for having me here this afternoon, this morning here in Buenos Aires. My argument today is a simple one. It refers to the connection between law and social change in the Latin American context, where, as you know, it was mentioned before, there is a strong corpus juris and a considerable set of decisions regarding the social minimum that seem to encompass all spheres of human rights protection. But at the same time, the existence of these precise and carefully drafted standards to guarantee social, economic, cultural, and environmental rights does not seem to have had any effect on the social reality of the most disadvantaged in Latin America. I want to argue that this gap between law and reality has become particularly evident in the context of the COVID-19 pandemic, precisely to the rapid response that the inter-American system gave to the crisis. As global, unforeseen, and dramatic as the pandemic is, its impact over Latin America presents for me some features that can help us to evaluate and eventually reduce this gap between the rhetoric of rights and their full enjoyment, particularly regarding ESC rights and the guarantee of the social minimum. Among these characteristics, the Inter-American human rights system, with all its deficits and shortfalls, has become for us over the years a strong safeguard, a guide, a reminder of what Latin American states should do in order to secure dignified living conditions for all the people in the region. This also has been the case in the context of the pandemic, as I will try to illustrate next. Despite I'm sure you know, despite general occasional improvements, particularly in the distribution of wealth, Latin America and the Caribbean remains the most unequal region in the world. In fact, 11 of the 20 most unequal countries in the world are in the region. Huge social divides, poverty and extreme poverty. As of today, 30% of the population lives in poverty and 11% in extreme poverty. A lack of or poor access to drinking water and sanitation, food and security, environmental pollution, lack of adequate housing, high rates of informal sector jobs, up to 53%, meager incomes, high rates of generalized violence, particularly based on gender, race, or ethnicity, and the persistence of corruption and impunity. All these are traits that have defined Latin American societies for decades. But regional problems are not limited to ESC rights. Civil and political rights are also affected on a daily basis almost everywhere, from Mexico to Argentina. Those who want to exercise their right of social protest may face disproportionate use of force by state agents. There is also severe crisis in prisons and a growing number of refugees, stateless persons, and expansion of migration and of forced internal displacement. Structural discrimination against particularly vulnerable groups, if not as pervasive as in other regions, has also been present in many Latin American countries for years. What I have just described is what we could call the Latin American normal, which clearly looks very far from a full region state commitment to secure a social minimum. So under this Latin American normal, the pandemic just added more significant challenges, both in terms of health policies and of the economic capacities of vulnerable groups to prevent contagion, secure personal safety, and ensure other social security guarantees, mainly jobs and decent wages. In summary, in brief, the pandemic has intensified existing problems and just introduced only few new ones in regards to human rights fulfillment. Let's examine now how the Inter-American human rights system has responded to this scenario. I think it's fair to say that the system has firmly reacted from the very beginning of the crisis, even before than most countries within the system. Its two bodies, the court, the commission, quickly implemented a number of actions regarding the pandemic. Sorry. On the one side, at the beginning of March, the Inter-American Commission established a rapid, what they call a rapid and integrated response coordination unit to the crisis. And 1 month later, on April 10th, it issued its Resolution 1, Pandemic and Human Rights in the Americas. This resolution, concisely, clearly details more than 80 recommendations to secure ESCE rights, while also demanding the full respect of civil and political rights affected in some countries under the argument of the state of emergency. As an expression of the principles of interdependence and indivisibility, the resolution also connects both types of rights with strict considerations in regards to the special needs of vulnerable groups, which is a good example of an intersectional approach. It focuses on the special needs of older persons, persons deprived of liberty, women, indigenous peoples, migrant, asylum seekers, refugees, stateless persons, victims of human trafficking, and internally displaced persons, children, LGBTI persons, persons of African descent, and persons with disabilities. On the other side, on April 9th, the Inter-American Court issued a statement titled COVID-19 and Human Rights, the problems and challenges must be addressed from a human rights perspective and with respect for international obligations. And on May 26th, the president of the court issued what, in my opinion, is the boldest move of the system so far. I'm talking about the adoption of urgent provisional measures according to Article 63.2 of the Inter-American Convention on Human Rights, in a case that was the stage of monitoring compliance with judgment. Because the case is Vélez Law v. Panama. This is a case related to the deprivation of liberty without an individualized determination of the necessity and proportionality of the arrest of migrant children, pregnant women and girls, all of them being held in severely overcrowded places and lacking adequate medical care. The order demands Panama to secure the rights to health, personal integrity, and life without discrimination to all the people deprived of liberty in the Darien region. Provisional measures such as these are frequently considered to be an efficient tool in cases of extreme danger or risk to life or integrity. However, despite the resolute nature of the president's decision, we have yet to see any concrete improvements in the Tapón of Darien. It's also worth mentioning that there have also been other documents on the subject. For instance, a very complete dossier, number 28, on the right to health, where the court analyzes the right to health as a social right itself, but also in connection with the prohibition of discrimination, the right to life, to integrity, to freedom of expression, to access to justice, to education, to social security, to water, and regarding people with disabilities. So again, the court on interdependence, indivisibility, and intersectionality. So all of this shows that even though the Latin American states are well behind in terms of guaranteeing dignified living conditions to the most vulnerable, the Inter-American system provides a powerful legal framework to weather the pandemic with a human rights approach. But this is not about any human rights approach. In accordance with its decisions of the last decade, the Inter-American system has applied this time, the pandemia time, a comprehensive approach that requires the consideration of the triple character of human rights to respond to the COVID-19 crisis. It's, again, its indivisibility, its interdependence, and its intersectionality. Both the Commission and the Court have placed these three principles at the core of any human rights approach in all government policies. In other words, the notion that all rights are connected to each other, that the full exercise of civil and political rights requires the full enjoyment of economic, social, cultural, and environmental rights, and vice versa, as the pandemic has proven. That it is not possible to secure the social minimum, specifically the right to health, integrity, and life, without securing all the civil and political rights that the rule of law requires. Let me finish with some considerations about the situation in Argentina. In March 2020, when the first COVID-19 cases arrived in Buenos Aires, the country was already facing yet another economic crisis. Unemployment was rising, and the population, particularly working and rapidly diminishing middle classes, were already suffering the impact of a prolonged recession. The future of the country once again depended upon the outcome of a major negotiation, a new agreement on the foreign debt, essential to avoid default. From March 11 to March 19th, the new government issued a considerable number of executive decrees, invoking the Constitution and human rights treaties to establish what can be called a crisis regime, but without resorting to declaring the state of siege. The hardest measure adopted was the quarantine. High levels of peaceful compliance with the measures were likely linked to fear of the virus, as everywhere, but also to sanctions because the government initially deployed security forces on the streets and decided to apply the rules of the criminal code on epidemics. As everywhere, the impact of the measures led to a contraction of industry and employment. In our case, the impact is similar to that recorded in the crisis of 2001. With an informal economy of around 40% of workers without a contract or access to social security, it must be remember, however, that Argentina does have universal health care and free public education. That's important. Anyway, the quarantine was a hard blow for those who do not receive a fixed salary. At the same time, the suspension of classes meant the interruption of food assistance in a country where millions of children eat daily at schools. But so far, the decision looks adequate in terms of securing the right to health, integrity, and life. In other words, in terms of securing a social minimum or dignified living conditions under the pandemic. This has been the case because as a way to soften the impact of the quarantine, the government has accompanied the restrictions with a comprehensive package of social measures focused on those most affected by the economic crisis and the quarantine. Measures range from extraordinary bonuses for the lowest income beneficiaries of the pension system, 3 million people, and for those who receive the universal child and pregnancy allowance, almost 4 million people, to two transfers of almost $200, let's say, each to the 8 million people affected by the loss of a gross decrease of family income, 57% of whom are women. The main objective of this deployment, which includes other measures to reach circa 1.3% of the GDP, was to ensure compliance with the confinement in specifically in low-income neighborhoods whose inhabitants need to go out to work to obtain a minimum livelihood. In a country where 3 million people suffer from housing deficits and live in overcrowded conditions, such as Argentina, without essential services, we have 5,000 emergency, what we call villas, favelas. It's impossible to stay at home when an entire family lives in 20 square meters or access to water is 200 meters away. That is why the government bet on this community isolation, a kind of third world version of the quarantine, urging people not to leave the neighborhood for which it was essential to provide at the very least food. And there were also a considerable number of measures adopted by the government that would take me long to enumerate, but basically aim to protect workers and to avoid the loss of jobs. However, the level of compliance, the effective coverage of these extraordinary social benefits implemented by the government, the access of undocumented population to them, and the situation of women in the most vulnerable and informal sectors raised some of the many open questions about the success of the measures. As I mentioned, in March 2020, Argentina was already facing enormous challenges. The COVID-19 has only exacerbated them. From an economic point of view, for those of us who have living memory of the 2001 crisis, it is not difficult to imagine what to expect once the confinement is over. From the point of view of guaranteeing a social minimum, the toughest prospects loom over the most vulnerable children, the victims of gender-based violence who have lived through the last months with their abusers, and especially disadvantaged women and men who are suffering the accumulated costs of poverty, informality, and exclusion. It's out of discussion that the quarantine has saved many lives. What is not clear after 3 months of lockdown is how many lives will not be saved due to the economic crisis. As Hölderlin once wrote, and I quote, but where the danger is, also grows the saving power. Will the Inter-American system, with all its resolutions, decisions, dossiers, and guidelines, save the social minimum? Or will us all be saved by renewed democratic political conversation? Is there anything more than the Inter-American system can do within its legal mandate, having issued such as comprehensive guidelines? Or is the problem root in social, cultural, economic, and political dynamics that the Inter-American system will never reach because it was not created for that purpose? Do we need more activism on the side of the system or a more effective institutional engineering at the national level to secure dignified living conditions for the most vulnerable among us? At the moment, I don't know whether the Inter-American system has had any concrete impact on the lives of the most vulnerable Latin American people weathering the pandemic. What I can hope is that if we eventually have to resort to it, seeking redress for the damage caused by our states, it's clear and exhaustive standards and regulations regarding the social minimum will for sure secure as fair an answer as possible. Thank you.
Mary, thank you very much for your presentation. And we have our last speaker, and Tomer is going to introduce Ignacio Saez.
Yes, thank you very much also for the very important regional perspective. Maybe this is also the time to say that anyone in the audience who want to ask questions through the less interactive but nevertheless effective Q&A option, then please do so in the, say, in the next 10 minutes, 15 minutes, or at any time on any of the issues, from the broader ones to more specific, so that we'll be able to raise them in the Q&A after Ignacio Saez's presentation. Briefly, Ignacio Saez is the Executive Director of the Center for Economic and Social Rights, or CESR, an international non-governmental organization with staff in New York, Bogota, and Johannesburg, working to harness the power of human rights to inspire just and sustainable economies. Prior to joining CESR in 2006, Ignacio was Director of Policy at the International Secretariat of the Amnesty International. He also served as Deputy Director of Amnesty's Americas program, overseeing the organization's work in Mexico, Central America, and the Caribbean. So this segues nicely from Mary's regional, but now also more global perspective. And he has an L11 International Human Rights Law with distinction from the University of Essex in the United Kingdom. So Ignacio, please.
Thank you very much, Tomer. Thank you, Elena, all the organizers of this webinar, and to my fabulous predecessors on this panel. I hope my presentation will be complementary to others in two ways. I'm going to give more of a fiscal focus. In other words, I'm not focusing so much on the meaning and content of social minimum or the right to social security, but more on where the money is coming from to fund expansive social protection schemes that we all want to give effect to in this context. My focus will also have a more of an advocacy orientation than perhaps a legal scholarly one, simply based on the perspective of my organization, CSR, which is a campaigning organization on economic, social, and cultural rights. So there is widespread agreement that we will need a massive investment of resources to tackle COVID-19 and to address the impact of its economic fallout, in particular on people's rights and people's livelihoods. And big new ideas are now on the table that were previously thought profligate and outlandish, such as universal basic income guarantees. But funding such measures will demand a radically different approach to fiscal policy than that which has been in place in most countries, certainly in the decades since the last global economic crisis, which fiscal policies have been characterized by austerity and by massive reductions in social spending. Now, expansionary fiscal policy has become a critical tool to enable emergency responses to the pandemic that respond to the scale of the crisis. And countries across the globe have been putting in place trillion-dollar economic stimulus packages aimed at strengthening health systems, expanding social protection, preventing mass unemployment by, for example, providing support to small businesses. However, few governments are taking human rights obligations into account in these interventions, many of which have been much more responsive to the interests of powerful corporations than to the rights of communities most affected by COVID-19. So my starting point is that bringing about the kind of rights-centered transformations in social protection that we're envisioning in this discussion demands that we also bring human rights to bear on fiscal policy, i.e. the way states generate, allocate, and spend resources. And so in my remarks, I want to share with you 5 critical challenges stroke opportunities that we're seeing at the Center for Economic and Social Rights for holding governments accountable to their human rights commitments when mobilizing resources in response to COVID, and to share with you how we and our allies are responding to these challenges. Our work in this area, I should say, stems from the conviction that human rights, that the standards of human rights, and in particular, the standards of economic and social rights, provide a roadmap, not just for the short-term choices that governments should make on economic relief and recovery measures, but for a longer-term systemic shift away from an unsustainable economic model, which is based purely on the pursuit of profit and growth, towards a much more resilient one based on caring for people and the planet. So a first basic challenge is that, frankly, economic and social rights standards are at best little known to most fiscal policy decision makers, and at worst, they're willfully disregarded by them. Now, we know that there are a few countries in the world, such as the USA and Saudi Arabia, that have not even ratified the Covenant on Economic, Social, and Cultural Rights, and so these countries often deny altogether that economic and social rights obligations apply to them. But even most of those countries that have ratified it, in these countries, very few ministers of finance or parliamentary budget committees are very likely to have the covenant's provisions foremost in their mind when they're reviewing and approving COVID relief and recovery measures. So in recent years, a growing number of human rights activists, particularly economic and social rights activists, tax justice campaigners, progressive economists, development advocates, have been coming together to change this state of affairs, working very closely with social movements who are often closest to the communities most directly impacted by unfair budgetary decisions. And these efforts, which we at CSR have been very active in, have kind of sought to translate the powerful but somewhat abstract and technical principles of economic, social, and cultural rights, the duty to mobilize the maximum available resources, to progressively realize rights, the duty to do so without retrogression or discrimination, the duty to cooperate internationally in this regard, to translate these principles into practical and useful tools that both activists, civil society activists, but also decision makers, progressive decision makers, can use to formulate specific changes in policy and practice. And I think this is a challenge for us in the human rights community. We're very good at elucidating perhaps the content of norms, but how do we make those norms actual guiding principles of public policy? And this work has really taken on renewed urgency in the COVID context, given the critical role of fiscal policy and the role that fiscal policy has to play in resourcing a just response and recovery from the pandemic. So just to give an example of how we and many allies are responding to this particular challenge, this first challenge, there's a crucial need to spread awareness of the advances in normative development that Michael and many others and Mary have spoken about, you all really have spoken about, thanks to the work of regional and global treaty bodies, to spell out those advances, to popularize them, disseminate them, but also to spell out their concrete policy implications. So an example of this is an initiative in Latin America that is called the Initiative for Principles and Guidelines on Fiscal Policy and Human Rights, which we are an active part of the steering group, along with colleagues in Argentina, CELS and ASIG, but also Fundar, De Justicia, and some other leading human rights organizations in the region. And this is an initiative to kind of derive more specific guidelines for policymakers in elucidating the implications of human rights norms for the design of fiscal policy at every stage in the fiscal policy making process. And there are, there's 10 principles, I believe, and we drill down, for example, on some questions around minimum core content and the imperative of putting in place universal social protection systems to give effect to minimum core content, and also the fiscal dimensions that flow from that. The notion of, as a guideline, we say that governments have to protect a certain amount of social spending that is commensurate with a reasonable understanding of minimum core obligations, and with all the complexity that David and others have highlighted around that concept. But just to give an example of how practical this kind of normative, more popular, more accessible normative guidance is, it's already been cited in challenges that human rights groups in Brazil have brought, for example, against the constitutionalization of austerity in that country. 4 years ago, Brazil actually included in its constitution a 20-year freeze on public spending. So for the next 20 years, Brazil has its hands tied. The next successive 4 governments in Brazil have their hands tied. So there was a challenge to this, invoking the Constitution's economic and social rights provisions, and that challenge has cited the Principles and Guidelines Initiative. So I'm giving this as an example of how these can be practical tools. And obviously that initiative is also aimed at working with national human rights institutions, with the regional, with the Inter-American human rights system also, to deepen its work on fiscal policy and human rights. And now we're drawing on these in the context of debates around COVID relief and recovery packages. And before I talk about that, that's my second challenge. I just want to say also that there's, our organization and many others are doing work that can be categorized as kind of literacy initiatives, expanding literacy on human rights as they are applicable in situations of economic and social crisis. Because, as I say, we may be very proud of the normative development that has been generated, but if it's not actually having a bearing on policy-making processes, then we need to bridge that challenge. So we're producing, for example, a series of issue briefs with other actors like Tax Justice Network, Latindad in Latin America, on different dimensions of human rights obligations, the maximum available resources concept, obligations of international cooperation and assistance, which are intended to spell out more accessibly to a non-human rights audience what these actually mean in terms of shaping responses to COVID-19. And this brings me to the second challenge, and I need to move quickly forward, which is how you actually bring these standards, these normative standards, to bear in the current context where governments around the world are putting together massive, $1 trillion economic rescue packages. At last count, some $5 trillion have been spent on these packages worldwide. In some cases, in some countries like Japan, these stimulus or relief packages account for more than 20% of gross domestic product. Yet there is a huge divergence, not only in their scale, but in the approach that different countries have taken, and especially in terms of who benefits from these packages. And it's very interesting to note, our analysis is that those differences correlate to some degree with how well or to what extent governments have integrated economic and social rights into their legal and policy frameworks. I mean, this is a piece of work that needs to be done more systematically, and if there are any students out there who want to help us with a research project on this, it would be very welcome. And also they vary in another factor that influences these divergences is the degree to which these packages have been influenced by civil society, by progressive civil society voices and actors. Because it has to be said that fiscal decision-making processes are often very opaque. There are great asymmetries of power around these processes, which means that civil society is very rarely able to scrutinize these responses as they're being developed. And I have to say that in some countries, the pandemic has been used by governments as a pretext to further restrict civil society space. Making it even more difficult to weigh in on these kinds of processes. I'm going to give an example of the divergence from two countries, my country of residence here in the United States and my country of nationality, which is Spain. Here in the US, as you may know, there was a large chunk of the huge economic stimulus packages, there's been a series of them, amounting to about $3 trillion, went to bailing out the airline industry and other large corporations to such a degree that it was described by many as a corporate coup, with very limited conditions on how those companies should spend the money. For example, conditions around keeping workers on or reducing carbon emissions. And the social protection measures in those packages were very limited, very palliative, one-off checks to individuals, with very limited expansion, for example, of paid sick leave provision. Spain, by contrast, and I'm not trying to be chauvinist here, I mean, we've been very critical of Spain when we need to be, but Spain, as you may know, introduced a universal basic income scheme in May, and not just as a one-off response to COVID, but as a permanent and structural fixture, followed by quite progressive measures introduced in April by the Ministry of Social Rights. Again, the framing is one of social rights. The program is overseen by that ministry and is explicitly grounded in the social rights guarantees in the Spanish Constitution. So in response to this challenge, and I'm going to move on, many of us in the civil society community, human rights community, are working on a kind of citizen's eye project, Ojos Ciudadanos, we're calling it in the Latin American context, to develop a rights-based framework, or at least basic criteria for assessing and monitoring these economic recovery packages to ensure that they prioritize the right to health, that they enable a massive investment in universal social protection schemes, that they avoid bailouts, that harmful corporate bailouts, and basically that they serve to reduce the huge racial and socioeconomic disparities that the crisis has made manifest. A third challenge is, it's all well and good to look at how spending packages are being, to what extent they're aligned with human rights, but we need to bring a human rights lens to revenue generation. How do you pay for all of this? I was going to give an example from our work in South Africa, where you can't enter the debate around spending unless you also look at how resources are being generated. In South Africa, there was, and David will know this better than me, there was a lot of debate around, there was a coalition campaigning for a top-up to child support programs in the context of COVID relief packages. And the government in the end limited the top-up to a transfer per carer, per child carer, rather than per child, which sounds like a technicality, but actually it's estimated to have left 2 million kids below the food poverty line in South Africa. And it's a decision that's hard to justify when you look at the resource generation. The government's COVID rescue package didn't really sketch out ways in which domestic revenue could be mobilized more equitably. And our partners, the Institute for Economic Justice in South Africa, had made a reasonable estimation that a wealth tax on the richest 1% in South Africa could have generated more than 10 times the additional cost of extending that top up to all children. So it's really necessary to look at the two sides of the fiscal coin, generation and spending. So I'm because my time is running out, I'm going to be very brief on this, but there's a real need to bring a human rights lens to progressive calls for progressive tax reform that are coming from outside the human rights community. And some of the specific proposals that we and many others are trying to bring a human rights rationale to are greater support for wealth taxes, for robust wealth taxes as a solidarity surcharge, taxing excess profits, particularly from the few corporations like the tech giants who are reaping huge rewards from the pandemic. It should be noted that in the first months of the pandemic, billionaires, particularly from the tech sector in the US, reportedly got $400 billion richer over this period. So, inequalities are really widening over this period. And proposals to create a more progressive tax system overall. I can expand in detail if we have time in the questions. The fourth challenge, however, and this segues on from this, when we're talking about tax systems, we can't just look at the national level alone. There is a desperate need to invoke human rights more effectively in advocating for international cooperation at a time of rising nationalism and weakened multilateralism. We have seen how there's been an alarming lack of international solidarity in global responses, particularly on the resourcing side. You know, the economic relief packages have really been framed at a very much at a national level with national interests at heart. And yet, you know, the economic impact of the crisis, as David mentioned, is especially dire in the global south due to a cascade of economic shocks which have accompanied the pandemic. And so really spelling out what obligations of international cooperation and assistance mean in this context is really critical. And I know that's going to be the subject of Monday's seminar. But three fronts on which human rights activists are working: interrogating the massive aid packages being put together by international financial institutions, you know, which are obviously needed, but many of which seem to be going to, for example, fund projects and initiatives that actually could lead to environmental harm, to displacement of communities, to food insecurity that could come with longer term, with austerity related conditions attached. The second, weighing in on issues of debt relief. There have been tentative and modest moves in that regard, but they need to be expanded to much more general debt forgiveness and cancellation. And more generally, other steps that are needed at the international level to prevent a hemorrhaging of resources from global south countries, including allowing capital controls, urgently tackling tax abuse and illicit financial flows, and stopping corporations from suing governments under investment treaties, for example, when they take action to protect public health and human rights. These are some of the fronts on which human rights activists are bringing the instruments of extraterritorial obligations and obligations of international cooperation to bear. I will end by saying that the fifth challenge, and I'm finishing now, Elena, the fifth challenge is, and the longer term one. How do we move from these kind of reactive initiatives to a more propositional approach in this context? You know, while we need to be working on these kind of rapid responses, this work needs to be crafted with an eye to catalyzing longer term systemic change on the issues that we're talking about. The crisis has really exposed the inequities of the neoliberal consensus, which has dominated for the last 30 years. And that's been the context in which we've been battling for social minimums. I mean, it's sad that we're even battling around, you know, the concept of defending minimums rather than a more maximalist approach. The crisis has opened an extraordinary window of opportunity to build a new vision and a new narrative around the economy centered on values of human rights, equality, and justice. As with the previous global financial crisis, this window may prove short-lived and it may shut very soon. So ensuring that our community, the human rights community, is able to scrutinize economic responses, to challenge economic orthodoxies, to push for more transformative alternatives, that's going to be crucial if this opportunity is not to be lost. Thank you.
Thank you very much, Ignacio. And I would like to thank all our fantastic speakers, Yuval, Michael, David, Mary, Ignacio. Extremely interesting, extremely important from different universal and regional perspectives, and bringing a lot of burning problems to our table. We unfortunately have absolutely no time for any broad discussions, but I believe it's because it is very important presentations. I would suggest the following solution. We may summarize the questions which we received through Q&A and questions we initially had while planning these seminars in three most important questions, like big questions, and you will have in your last word an opportunity to address one of them if possible. Okay, I will give each of you one more time a word. So the first bench of questions relates to which particular threshold we should meet during the pandemic, because we can interpret dignified life differently, as we already heard in different presentations. Dignified life as providing just minimum core obligations, or protecting people's lives, or protecting them from torture, or we should meet a certain level of sufficiency already also in the time of emergency and providing a certain sustainable level, as Ignacio mentioned. So which standard? This is one point. Second, how within a decent minimum we should balance human rights? There is a huge problem of derogations of many states from their obligations under various treaties. So the states, in order to protect the whole population, are trying to sacrifice their obligations to refugees, obligations not to cut social support, and so on. So how we should really balance, where is the balancing tool? And the third, I skip the responsibility of non-governmental actors because we are going to address them in our next seminar, and we'll come to the last question. It is about the efficiency of contemporary international regional complaint mechanisms to protect individuals and social groups, to what extent they are really effective, or whether some other measures like protest-based activism is currently more effective, or they should be also harmonized. Please, I open the floor, and you can start. Yuval, you answered almost all the questions, and probably you can try to start with.
I wanted to start because I apologize, but I have to leave at 5 o'clock sharp Jerusalem time because I'm hosting. Actually, a meeting of the committee's bureau, so and it's on my Zoom account, so I have to be available. I wanted to make two points very quickly. One on your last point, Elena, on whether the mechanisms for complaints are effective. In one word, the answer is no. They're not effective. I mean, I would say that even in ordinary times, I mean, they're a very slow response. I mean, they could provide you. They're not really geared up, at least the treaty body mechanisms are not geared up to provide you with instant justice or anything which is in that nature. And I should say that one of the reasons why I'm having this other meeting is that we are, the committee is stopped the meeting because of the COVID-19 crisis. I mean, Geneva, the UN facilities in Geneva are not open for business. So the whole work of the treaty bodies had been derailed, and it's not even clear that our upcoming session in July would have proper interpretation facilities. I also saw earlier today that the ILC has canceled its meeting this year. So the whole UN apparatus is, to put it very diplomatically, has been side railed by this crisis. Okay, it is not. I mean, it's a big ship, and it's not responding. So over and beyond the general problems with this mechanism and the inefficiencies and the slowness, dealing with an unexpected catastrophe is really overloading the capacity of the system. I'll just use one word of caution about standards. I mean, I think it's a very important discussion, the standards, and I appreciate David's three-tiered approach. I think this is very useful. I do want to recall that Article 6 and 7 under the ICPR are non-derogable, which is, of course, a very important feature, but that also means that there are limits to how much we can upload on them without actually jeopardizing the consensus around them as non-derogable, because a lot of the issues we were talking about have elements of balancing. Once we're in the area of balancing, there are limits to how much mileage we can get through invoking in provisions such as Article 7 that are not subject to balancing. So we have to be a little bit careful about what we wish for in terms of uploading to very heavy instruments that we have, like Article 6 and Article 7, very important, but somewhat more nuanced and context-dependent elements of international human rights law. I thank you very much. I will have to leave in 2 minutes. So thank you.
Thank you very much, Yuval. It was very important. Thank you. Probably Mikhail could continue.
Yeah, thanks a lot. I also have to leave at 5 for the next meeting. This is times in Zoom conferences where you always have to sharply change two thoughts. First, on the threshold. I talked about universalizing the right to social security as a very important component, but I was less talking about minimum core content or something like this, yeah, because it's progressive realization, and we shouldn't define what is the minimum, because then states always will stick to what we have defined as a minimum. And if we reduce it lower and lower, it will be less and less costly. And then they say, oh, this has been defined as the core of the core. Let's stick to the core of the core and not more. No, we have progressive realization. The right to social security means more than just having the core. As many economic, social, cultural rights needs more to allow a life in dignity. So we can talk about maybe a first step of a progressive realization, which needs, at the other hand, to be universal. I think I would differentiate two things. It helps maybe not to be too much diving into the threshold discussion. Yeah. And secondly, your question, what is the complaint mechanism of political activism? I think we have two major differences in getting the things moved. First, I was addressing by saying there is a lot of proverbs against social security of being payments to lazy people. This is one of the most essential hindrance point in many national politics. This needs to be challenged, and we have to be actively doing this. And the second one is you have to use the money. Yeah, and probably we don't need to have only literacy, Ignacio. We need really the political power, yeah, because money is available in most countries if you put it where it should go, at least for this minimum core contents, yeah. And it's a political discussion to say it's a deliberative, enabling facility for people who are otherwise excluded from societal life, and therefore we have to battle. And this can be used. We can use complaint mechanisms, but we also need political support, and we have to win it at the national level, these debates.
Thank you very much, Michael. It's very significant contribution. David, probably you can continue.
Thanks, Elena. Well, it's a good point, because Michael raised quite a controversial question for me, because I don't agree that we shouldn't define thresholds, because I think we actually have to define the obligations that states have. And so we have to understand those obligations. And therefore, I understand the point perhaps about leaving things constructively vague, but it doesn't help people, in my view, who are on the survival threshold. And people then say, well, you don't really have a priority obligation to ensure that that's realized. So my view is progressive realization starts from the minimum core. And from the minimum core, we progressively realize outwards. The obligations in terms of social rights are not obligations only towards the minimum core. They're obligations to the higher sufficiency threshold and to reach that. But for many places of the world, it's not possible to reach that. And countries in the global south experience that particularly harshly. What thresholds should we do in these kind of contexts? It seems to me, let's not make people worse off. That's negative obligations. To some extent, it will be society dependent about what people and what a society will tolerate. Priority needs to be given to the minimum core, minimum threshold. And then there are global justice questions. If some societies are living a very high life and others are not even able to feed their populations, there is a question of transfer of resources between those societies. And so it seems to me that that will implicate the question of the next seminar. And just to deal with the last point, I was asked specifically about balancing the protective obligation in relation to a pandemic against protecting people's vital sources of food or income. And let me just say, it's often presented as an either-or choice. And I think part of what I was trying to say, this is not an either-or. We're ultimately concerned with ensuring people survive, ensuring people are able to live and in the future be able to flourish and get a higher level of provision. And in order to do that, we have to approach it. I've suggested a reasoning process which takes account of disaggregation and aggregation. The first step is to disaggregate the various social rights and consider what are the impacts on the various dimensions, of people, health, food, social security, water. We then determine a minimum and sufficiency threshold for the achievement in relation to each of those goods. We then understand the impact of the health crisis on the realization of those thresholds. We then consider what measures must be taken to address the inability to realize the thresholds. And then we have to deal with trade-offs between the measures we take. And there I've suggested, and others have agreed, I think there's a lot of agreement between us here, of the usefulness of a proportionality analysis. Why? because it's a reasoning structure that allows us to think through carefully the various parts of the balance and whether we are taking, in particular, the least restrictive means. So, in other words, we're being very practical, and I agree with Ignacio, we must be as well, okay? We can't lock people down with no economic support. We can't say to a disabled person who's not able to go and collect food support, and there's no mechanisms to do so, you're locked in your house and then you must starve because we're fearful of COVID-19. This makes no sense. If people who don't have transport, we need to think through those things. So thinking in a practical terms, we have to, there are just justifications. I'm not saying all lockdown measures were incorrect, but they do have to be thought through, and there have to be other measures in place to avoid the other serious threats that arise into people's survival. And I think I'll leave it there, and we can engage further in other contexts. Thank you. Thank you very much again. And thanks to
Thank you very much, David. Mary, would you like to add something on any of the points?
Briefly. As a practitioner, definitions are essential. We need definitions. So that's David's point. And regarding your question on mechanisms, I would ask, what do we want? We want more citizens, more rights, or more victims? If we focus on victims, we will focus on more biggest bureaucracy. But if we focus on more enjoyment of rights, on citizenship, we will we have to focus on policy, on the democratic dialogue, on a stronger democratic dialogue. For me, that's essential. We can see that at the CRC committee, children going there to ask for their rights. It's not working. It's good, but it's not enough. We don't want victims. We want citizens.
It's a great point. Thank you very much, Mary. And Ignacio.
Yeah, so I want to respond to the great question on the chat, which you picked up on, Elena, about, is protest-based activism and promotion of awareness and literacy, is that the only option? Absolutely not. I mean, there is a whole spectrum of ways in which progressive people, human rights activists can engage in this context. I mentioned the literacy and promotional work as one piece that's needed to be able to to enable other forms of activism. But I do think there's a critical need to raise awareness of government human rights duties beyond the human rights community. There are many examples of how people are using around the world human rights complaint mechanisms quite effectively, from a Supreme Court challenge in Mexico that's about how informal settlements are included in the census. That doesn't sound like a COVID-related thing, but it is fundamental to questions of who's counted in this context. To the court challenge I mentioned in Brazil, against the constitutionalization of austerity. There is, mobilization around regional human rights bodies and treaty bodies. I do think that thirdly, policy advocacy around the kind of resource mobilizations that are going on now around economic relief and recovery packages are a crucial entry point that we in the human rights community, I don't think are capitalizing on enough. We're not engaging in as directly as we should. And that work, those debates are happening at the local level, at the national level, and at the transnational level. There is that longer term work I mentioned, which is around, envisioning a rights-based economy. I know that sounds grand and utopian, but I do think it's a longer term task that we need to be focused on. And for that task, I mean, we need to build collective counterpower. Because I mentioned that there's a window of opportunity that is going to slam shut, just as it did after the global financial crisis. And why did it slam shut? Because the vested interests, the typical economic interests that are interested in preserving the status quo are more powerful than we are. And they have far greater access to power. They've captured power much more than we can ever dream to do. And so to counter that, we in the human rights community, I think, need to join forces with other actors for economic justice, with other movements, with the labor rights movement, with tax justice campaigners, with progressive development advocates, because we alone are not going to be able to build the kind of power on the scale that is needed to respond to the current crisis. And, I wouldn't knock good old-fashioned street protest. I mean, I know right now in our contexts, there are very grave limitations for going out into the street. I'm based here in New York, and as you probably know, there have been 3 weeks of street protest because of the police brutality, the racist police brutality here in the US and everywhere. And there I have seen, and I can bear witness to the power of good old-fashioned street protests. There have been some amazing reforms already in this country, and particularly in various states, that are due to the power of well-organized street protests. So my point is just that there's a whole spectrum of things that we in the human rights community can do, a whole spectrum of types of advocacy and activism that we can lend our voices and bodies to.
Thank you very much. Tomer, do you have something to add to the, or we should start summarizing? I guess,
I know, I think we're over time, and of course this could go on, and we have a continuation next week, so.
Yeah, I would like to thank all our fantastic speakers for their amazing and highly interesting and important presentations. We are indeed happy to have you here and enjoy communication with you. Thank you for all the participants for their important questions. Some of them have been answered. And I would like to thank specifically the Minerva Center of Human Rights, those contributing to the workshop, especially Tomer, Danny, Elena, and Anat. Thank you very much. Without you, it would not be just possible. And indeed, our second webinar on extraterritorial obligations to cooperate and assist in the realization of the right to a decent social minimum in the time of pandemic will be on Monday, June 22nd, from 2 to 4 Jerusalem time. So all of you are very welcome to join the discussions. Thank you very much.
Thank you.
Thank you. Yeah.